All right, sir, are you Gabriel Cruz?
Yes, ma'am.
And we've got cause numbers 26 DCCR 0373. Mr. Cruz is charged with stalking. Cause number 26 DCCR 0374, charged with violating a protective order. And then cause number 26 DCCR 1060, charged with violating a protective order. And the state has filed a motion asking that I increase the defendant's bond. Hold on, I need to see what the bonds are in each case.
I believe they're
$100,000
In all three cases?
Well, individual, $100,000 in each individual.
300,000 total.
That's
Yes.
what I need to know.
Yeah.
All right. And has not made bond in any of those. Is that
He-
correct? Or he
He
has?
made bond in the first two, and then he picked up the last new case, and he's in jail on that case, on that. He has not bonded out on that charge.
And the last offense, it looks like has that same offense date. It was just indicted on, at least on my docket. Let me look at that.
Oh, it's a different offense state. It's my understanding.
Let me look. Oh, okay. Hold on a second. Offense date. It's not, okay. It's not. So the offense date in that last one is March 1st of 2026.
That's right.
So 2 weeks or so after the first alleged offense of violating a protective order. Mr. Coleman, you may proceed.
Yeah, I filed a written motion. I have no doubt the court's reviewed it. I'll just hit the highlights if I may, Judge. The criminal history, I just would ask that the court reevaluate the bonds in light of this defendant's criminal history that includes the conspiracy to possess or distribute cocaine out of the federal court, 2010, unlawful carrying a weapon, Jefferson County, 1994, possession of controlled substance, 1998, an adjudication for possession of marijuana, state jail amount of marijuana, 1998, and a arrest for an aggravated assault that was ultimately dismissed. I think it's still probative in this setting, that history. And in addition to the criminal history, Judge, I'd ask that the court consider the fact that this defendant allegedly committed this new offense of violation of protective order while out on bond for violation of protective order, and it involved the same victim, Judge. I think there are a lot of concerning issues here related to public safety and the safety of the victim in this case. I submit to the court that $100,000 bond on each of these cases is insufficient. I'm proposing a bond of $250,000 in this case.
Yeah.
I'd ask the court consider this.
I'm printing a couple of PCs as well. Give me just a second. I'm gonna get some stuff printed out so I can take a look at that. The PC in both of the in all of the cases, so.
Mhm. What do you do? No.
Y'all stop talking.
Sorry.
Was there one more that printed or not? I guess. Okay, I see. So the, one of the stalking and protective order is the same.
Day.
He
Yes.
said.
That's right.
Mr. Parker?
Your Honor, I would like to point out that this is, he and his wife are going through a divorce and it's been nasty. Part of part of the communication or contact with her was because she wanted him to see the child and told him to come get the child. And that's why he was there. I think I can't just, and give me judge, I haven't talked to him after he bonded out. So I don't have a whole lot of information and I just received a new case. So I'm not familiar with all the facts of the new case. So I'm limited to what I know. But a lot of what my communication with him is that he's been contacted by her and I'm sure she was admonished by Judge Freeze or whoever that to not contact him. But he did say that was one of the reasons she has contacted him to see his child, and then she tries to use that against him, and which is common. We see this a lot of times. There's a divorce going on, and they want to use anything they can. But you know, we're asking that. I mean, he's on there's third-degree felonies, and $100,000 is a high bond. He had some help on the first two cases. I'm not sure if he's going to be able to have that help on these cases, but we're asking to leave the bond the same, $100,000 on with other restrictions, I think is appropriate for these types of cases. If he was out and was intended to hurt her, he could have hurt her. I think, you know, even the facts that Mr. Coleman has raised and some of the stuff is that if he was around her, you know, he could have hurt her if he wanted to. But I think it aligns with what he is telling us that he was, even though he shouldn't have gone over there to see his child, that's more than likely what happened. So we're asking to keep the bond the same, Judge, with other monitoring restrictions.
Right, so Mr. Cruz, if you have a protective order against you, I know what those say, and I know what the judges and the magistrates tell you about that. No one can give you permission to violate that protective order. And if you guys were just talking about a visitation of your child, I wouldn't have a probable cause that has an allegation that there was 96 text messages, 47 emails, 9 voicemails left stating that you don't care what the protective order says and that you're going to do what you want to do. In addition to pulling in the driveway, that's on February 23rd. 2 weeks later, same thing, numerous calls, and the officers locate you in your vehicle a block away from the house driving past. So it obviously, regardless of whether you have already done anything to hurt her, my job is to make sure that that doesn't happen. And I feel like you have completely disregarded the protective order that was placed on you and the rules that were placed on you down in another court. And so at this time, I'm going to grant the state's motion. I'm going to raise the bond and cause number 26 DCCR 1060, which is the last offense date of March 1st of 2026. I'm going to raise that bond to $250,000. Condition of that bond, if you make it, is that you wear a GPS monitoring device at all times and that you would be on house arrest as well. So you would not be allowed to leave your house. I am going to modify the conditions of your bond and the two other cases that you've already made bonds on. Additional bond conditions in those two cases, which is 26 DCCR 0373 and 0374, are that you have a GPS monitoring device on at all times and that you are on house arrest. You're not allowed to leave your house without my permission. All right, you can go back with the bailiff. We'll set your case for an announcement.
The bond amount stayed the same in that one?
Yes, I didn't
Okay.
change those bonds amount. I raised the last one
Okay.
and made those modifications.
Okay. I did. Hey, I understand. Hey.
Sir, you're live in Stratton.
Yes, ma'am.
And this is 19-33601. Mr. Stratton is charged with capital murder. And what's the announcement?
Judge, we have gotten, I think, all of the media, but we're having a wrinkle with one of the police reports that's rather lengthy that Ms. Molfino is trying to figure out why it's not transferring over from the old program.
Okay. Other than that, though, everything has
Other than
been,
that, I'm missing about 20 or 30 pages of police report. Other than that, I think we're good.
And what we're doing, Judge, is somewhat equivalent to kind of a reverse manual bait stamp, if that makes any sense. With it converting from workflow to Odyssey, there was all kind of glitches, including the media. We have recreated that from originals at the police department. But maybe that some of it is merged into one another, but myself and intern are going through it this time and just documenting every single page number so I can get that to Mr. Rappert and he can tell me which 20 is missing, because just I'm missing 20 out of the 2 red wells I had. It was difficult and I wanted to, of course, have everything, but I think we've probably exhausted all of our discussions regarding the judge and are headed to the trial docket.
so is there any reason to believe that those pages out of that police report would change the position?
I don't know, but I doubt it, but I don't know.
So here's what I want to do. I'm going to give one more reset for an announcement.
Okay.
If the case is going to trial, I want to try it before the end of the year. So we're getting already halfway through the year. So we need to start looking at some dates and what's available if possible for the end of
I'd
the
like
year.
to get a special setting judge. I have some out-of-state witnesses that.
Yeah, no, it's going to definitely be, I think because it's the nature of it and we'll definitely make sure that when it's set, it will be the case to go. We'll do a
Okay.
protection order if you need it and
Yeah.
things like that. So we'll make sure everybody's available.
And
If you have any other cases that are set that you know are going, that are specially set, kind of maybe start an email with me, you guys, and we can start coming up with a date. Obviously, if something happens before then and it's taken care of, that's one thing. But if we want to start looking for a date, let's go ahead and start looking for that now.
I guess we can, after we get the next reset, we can have a pretrial conference in chambers and get some dates.
Yeah, I mean, just start an email
Okay.
and we'll start it that way. And
Because I have so many family members, I will reach out to them now and kind of take a look. If obviously with the age of it and the witnesses, et cetera, it's a lot of moving parts.
it is a
I'll try
lot.
to
So
get
that's
it.
why we need to get it set so that everybody can get everybody here and subpoenaed, and we don't, we can't. It's going to be difficult for everybody to be completely available, but if they know ahead of time and they're under subpoena, then they won't have a choice.
Do
So
have
I'd
a-
rather do it that
I
way.
do have a trip planned out of the country for Thanksgiving.
You'll just make sure you have that
I'll send that to him.
vacation letter
I
in.
will also.
Okay. All right. So let's just do 30 days. That way you guys can please get the police report. If that changes anything, we'll know then. Otherwise, between now and then, let's start looking at other dates, but we'll have one more announcement
Yes, ma'am.
before trial.
May I be
Okay.
excused?
Yes. Good morning. Are you Andrew Howard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Well, you're on.
Mr. Howard, in cause number 25 DCCR 0742, you're charged with a state jail felony offense of fraudulent use or possession of identifying information from April 18th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation exclusion from admission to the country, or denial of naturalization under federal law.
Yes, ma'am.
State tenders number one,
Objection.
it's admitted. Is there any evidence that Mr. Howard's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign a dismissal as part of this agreement and clause number 25 DCCR 0741, and this will also run concurrently with your federal case. Now, as long as,
They've already been sentenced over there, and I think we're good with that.
okay, I just
I've
want to make
explained
sure.
to him that.
Well, I'm going to make sure I explain it too. The federal system does whatever they want. So I'm going to say that this runs concurrently with their case, but that's completely up to them. Okay, so it sounds like it's going to be no problem, but if it's for some reason the federal system says it's not going to run concurrently and you have to do one before the other, there is absolutely nothing I can do about that other than what I say today and what the intention is. Okay.
Yes.
So that case is 1:25 CR 56. And as far as I'm concerned, it will run at the same time. Okay. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir.
Thank you, ma'am. That's up on too.
I have no idea about this. Is it Michigan?
I'm okay.
Well, I mean, I'm not representing, usually I put up, let them know.
Sorry, whenever I get to.
Oh.
I'll get with the misdemeanor prosecutor
Okay.
right now, email him and tell him,
Okay.
part of our agreement was to dismiss
Okay.
any misdemeanors that came out of this transaction.
So everything's 6 there.
Yeah, that'd be.
All right, thank you, sir.
Thank you.
Good morning. Are you Kevin Thomas?
Yes.
And Mr. Thomas, in cause number 26 DCCR 0798, you're charged with a third-degree felony offense and assault on a security officer from March 17th of 2026. Your indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, August 28th of 2000. And then after that was final, you were convicted of burglary of a habitation, second degree, September 29th of 2008. And then after that was final, you were convicted of possession of a controlled substance, a third-degree felony, March 30th of 2021. 2 cases of possession of a controlled substance on that day. And what that means, sir, is that if you go to trial in this case and you're found guilty, the range of punishment would be that of a habitual offender, which means it would be a minimum 25 years in prison up to 99 years of life. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Ms. Holmes that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on, it looks like maybe count 1 and count 2 to make this a second degree for a 15-year term in prison. You have every right to reject that offer. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Mr. Coleman, is there any reason to believe that offer would change?
Not at all, Judge, and in full disclosure, while the 15 years is a formal offer, I did make a today only offer for less than the 15 if the defendant was amenable to that, and he's rejected that as well.
And what was that for?
I believe 10.
Yeah.
10.
So you understand if you wanted to enter a plea of guilty today, there's an offer that was extended today for 10 years. Obviously that's going to be off the table, as will be the 15 after today. Do you understand?
Yes, ma'am.
All right, so we'll get your case set on the trial docket. Mr. Thomas, Ms. Holmes has been appointed to represent you. She's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release her and we can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Ms. Holmes, you'll be released. Mr. Thomas, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff. Good morning. Are you Justice Joanna Lewis?
And that's another fascinating courtroom moment. The defendant turns down a plea offer, even after hearing he could face 25 years to life if convicted at trial. Some defendants choose to fight because they believe they can win, while others reject offers for personal reasons. What would you do in that situation? Accept the deal or take your chances before a jury? Share your thoughts below.